Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is Who is Elizabeth Odette? Meet the chair of NAAG's Multistate Antitrust Task Force. State attorneys general have historically played an important role in investigating and challenging antitrust violations that affect their constituents. State antitrust enforcers don't just tag along in federal antitrust proceedings. They work closely with each other in many matters. Back in June 2020, we focused on the Multistate Antitrust Task Force of the National Association of Attorneys General in episode 65. How does everyone work together? The NAAG Antitrust Task Force and state enforcement. In this episode, we'll catch up on what the task force has been up to lately under the leadership of our guest. But before we talk about that, I'd like to welcome my co-host, James Hunsberger. Hi, James.
Hi, Alicia. Great to be co-hosting with you today.
Same here. Would you like to introduce our guest and kick off the conversation?
Absolutely. It's my privilege to introduce Elizabeth Odette, who's an assistant attorney general at the Office of the Minnesota Attorney General and has been with the Attorney General's office since 2020. Prior to joining the office, she was an associate and a partner at Lockridge in Minneapolis. In 2024, Elizabeth was appointed as the chair of the Multistate Antitrust Task Force of the National Association of Attorneys General, or NAAG for short, for a 3-year term. Welcome to our Curious Amalgam, Elizabeth.
Hi, thank you for having me.
So to kick us off and make sure all of our listeners are on the same page, let's start with a basic but really important question. What is NAAG, and what role does the Multistate Antitrust Task Force play within NAAG?
Yeah, so NAAG is a nonpartisan national platform that supports collaboration, training, and education for attorneys general offices and their staff. Its members include U.S. states and territories, with a few exceptions. There are a variety of committees and working groups that sometimes focus on industries or topics, and then there are ones that focus on certain areas of law. And so one of those is the Antitrust Task Force. And there are also, for example, groups that focus on consumer protection, charities, and med fraud, for example.
So you just touched on the fact that there are multiple task forces and groups within NAAG. Is there any way in which the Antitrust Task Force is unique or differs from other task forces?
Yes. So I think with antitrust, we are often co-plaintiffs with each other. And so that requires a need for greater coordination in investigations and lawsuits, rather than simply coordinating a number of state law investigations or cases. Working as co-plaintiffs, it means that each state can vote with their feet in different states of litigation. So that could be discovery, that could be litigation strategy, it could be settlement. And so that takes an incredible amount of coordination, combined expertise, and relationship building for multi-states to really be successful. And so back in the 1970s, in order to facilitate state antitrust enforcement success, NAAG decided to appoint a task force and a task force chair to help facilitate that work. And in that role, like my predecessors, I lead biweekly meetings that cover policy, proposed laws, new potential investigations, updates from federal partners. So we usually have the DOJ and FTC alternating on our calls. If there's any amicus or sign-off opportunities, and then, there's also sometimes comments. So there's just a ton of ways in which states can work with each other on antitrust initiatives. And task force calls are meant to kind of make sure that anyone who's interested in keeping up, if you have a state that has one person that wears many hats, they can jump on the antitrust task force call and kind of know what they need to know to do their job and keep their front office knowledgeable of what's going on in the antitrust world. We also kind of manage committees. So within the Antitrust Task Force, we have committees that focus on industries or focus on, legislation or other things. And so we coordinate those. We do trainings So we have an annual fall conference, and at that conference, it's exclusively for state enforcers. It's relationship building, but it's also kind of talking to the people who've been in the front lines of recent issues or cases to be talking with each other about lessons learned. My job as a task force chair is including, public speaking like this and talking about what the states are doing in antitrust enforcement, and then writing about relevant antitrust issues. And then, as I mentioned, we have the DOJ and FTC on our calls on alternating weeks. And that liaising with federal enforcers is another job that I have to ensure that we work well with our federal partners and keep those communication lines flowing. And then also with professional organizations like the American Bar Association Antitrust Section.
That's super helpful context and certainly sounds like you're keeping busy. You mentioned one unique aspect of the task force is that the states are often serving alongside each other as co-plaintiffs. And over the last many years, we've seen the states as highly active enforcers in at least two different capacities. The first being states working directly alongside the federal enforcers at the DOJ and the FTC, all together as co-plaintiffs. And the second being the states bringing standalone cases. Can you speak a bit to how the task force considers those two situations and assesses how best to proceed in individual cases? And in each scenario with so many different co-plaintiffs, how do the states organize themselves?
Yeah, so I would say it's never NAAG's role or job to decide which states get into which cases. That's obviously the front office decision, but what NAAG can do is help facilitate those line attorneys and the staff level recommendations that they have to make to their front offices. And where we have finite resources as government enforcers. And so we're always looking to find as many efficiencies as possible. And so where we are aligned on a particular antitrust issue, it's a priority, and it's where states believe they have a specific interest in advancing that enforcement or could add specific value to a federal case. Then the preferred route is to work together. Examples of state interests could be an industry that has a large presence in a state. It could relate to an issue that the Attorney General's office has been hearing about on a regular basis, or it could be an issue that particularly impacts citizens in their ability to afford basic needs. So there could be a variety of reasons why a state may see advantages to working with federal enforcers. And states could add value to a federal case by being in a good position to provide local discovery or to do witness outreach to be better understanding the local markets that are at issue or the local issues. Or there could be state claims that could align well with federal enforcement, and it could be civil penalties or the like. But I think the Antitrust Task Force works to facilitate these discussions at whatever level they need to be had, and then collaborate with the groups to make sure that they have what they need to be going forward. And then at the end of that process of state and federal collaboration, we often look at ways that what went right and what ways do we improve. So, for example, at our fall conference, often we do a retrospective of something that more recently happened where federal and state enforcers were working together and kind of hearing from the states involved and the federal enforcers involved on what worked. And then moving to when states decide to go alone, some instances it's where the federal action is still going on as well, but following evaluation of what the federal government is looking to get out of an action and what the state is looking to get out of the enforcement action. And there may be unique circumstances where that could be facts, claims, or potential remedies where it just makes sense for those states to move forward separately. And again, NAAG doesn't have any role in decision making, but tries to assist those making those decisions if there's any way that NAAG can help in collaborating on how there could be efficiencies. And regardless of whether there's co-plaintiff situation with the federal government or the states are going alone, there is coordination when there are common issues being brought. And within the larger multi-states, when you have them going with the federal enforcers or in large state multi-states, you have committees often that are working on things. So you may have finance committees, you may have expert committees, and, the effort for NAAG is to say, hey, are you making sure that you have a mix of big and small states, red and blue states, people with expertise, people that are new and need experience? So we just try to encourage a broad spectrum of opportunities so that maybe one state isn't carrying a heavier load constantly, even though they're really great at setting up the SharePoint or database that's necessary. That's great, but maybe trying to spread out the needs of different cases. And so the current big multi-states I can think of are, like Amazon, Apple, Live Nation, Ticketmaster. The last one, I think, being the largest. And, it depends on the procedural posture and the size of a matter of what committees are needed. But, I think depending on, from what I've seen from private enforcement or federal enforcement, the working groups are somewhat similar. It's just that we're across different states all working together on a matter.
Really appreciate that perspective, Elizabeth. In merger investigations, the federal enforcers may decide not to challenge a deal, while some states may want to continue their investigation or may have concerns and want to bring a challenge. How does the task force approach those sorts of situations?
So I think for the task force, we, are cognizant of and try to remind everyone who's part of NAAG that there are instances where staff level recommends one thing, whether it's to join or not join a merger challenge, and is overridden by their front office. And so, we just like to make sure that the dialogue is open about why those decisions were made and that everyone has everything they need to make a fully informed decision about their recommendation and then move forward based on how their front office decides. Each office is unique about the amount of resources they have and the types of expertise. And, as I mentioned, those resources and how much they're able to provide. As I mentioned before, we have a number of states, less than we used to, but a number of states still that have an individual who wears an antitrust, a consumer protection, a charities hat, and they have to navigate wearing all of those hats often. And what we try to do at NAAG is ensure that that person doesn't feel overwhelmed by the decisions that they're having to make in terms of staff level recommendations. And so we try to organize the information and the discussions in as efficient of a way as possible so that everyone can contribute and have what they need. I try to then also facilitate dialogue between federal and state enforcers, just like I mentioned with conduct. There could be instances where federal government decides to, bring a merger challenge, and some states may say, great case, but we can't, support or be on the case with you right now because maybe we're resource strapped. And just knowing that is helpful, I think, in the dialogue and not just simply not joining. It's better for us to be on the same page and have discussions about what the merits are. And so just knowing where states are can be helpful to move forward because you want to make sure that, there's always going to be another case. And so you want to maintain those relationships.
So shifting to a slightly different topic, you recently wrote an article in Competition Policy International, and it was called The State Antitrust Enforcement Venue Act, A Measured Approach. So listeners who want to see the article, we'll try to post one on the episode webpage. But could you share your views on the act and what effect it may have had on your options, how it might affect your strategy going forward at the state level?
Yeah, I was very curious. I was in my position at the AG's office when this was being considered and was part of the, very active dialogue around it. And then it passed in 2020, end of 2023. And so I really wanted to take a, retrospective. I think we were far enough away from it to see how states had really utilized it, if they'd utilized it. And what I concluded was that they'd really taken a measured approach, choosing to file and in venues of their own and separate from MDL or federal action when there were circumstances that were specific to the state, that they identified specific reasoning for their decisions and, kind of moved forward that way. It still didn't prevent coordination where there was the opportunity for coordination. But, I would say generally state and federal enforcement is a team effort, but sometimes there are those circumstances. And, I looked at the Kroger-Albertson merger where Washington and Colorado sued to stop the merger on their own in very specific, in their state courts for very state specific reasons. Another example is in Arkansas. The Arkansas Attorney General has a specific pesticides case that is separate from the multi-state and the FTC and certain states case in the Middle District of North Carolina. And while there is coordination for discovery, Arkansas chose to continue to have its case in Arkansas because of the implications and the importance of the pesticides to certain industry in that state. And you could also look at the new Texas-led lawsuit against 3 institutional investors, BlackRock, State Street, and Vanguard Group, where they're alleging that using their acquisition of stock to reduce competition in coal markets. That case was brought, I think, being able to know specifically that even if there were subsequent cases, private actions brought, that case will, absent other venue challenges, would stay where it was, and it would not potentially get moved to another venue through a multi-district litigation judicial panel order. And that was the case for a Google action and the generic drug action, which I think were in the dialogue when this law was being considered. And I think what I concluded in the article was that going forward, you may see similar measured approaches where states won't all be filing different, it's the same case in different states or the similar case in different states. And instead, we'll look very closely at what aligns with our priorities and do we have the resources? And if so, we will file separately, knowing that we're taking on that extra burden to bring it, but it's worth it for them after certain analysis.
Well, let's talk then specifically about the task force's policy priorities, as well as your priorities as chair. I think you have 2 more years left in your term. Can you tell us a little bit about what you see as the top priorities?
Yeah, so I think, I've been in state enforcement for 5 years. And in those 5 years, in recent years, I have noticed that state AG's offices across the country have increased their numbers in terms of state antitrust enforcers, which is great. But it also means that the antitrust task force has grown. And with that, there's been an added mix of individuals from a variety of areas, not just new lawyers, but people from maybe backgrounds that have litigation, but not antitrust, or, people coming from private practice with antitrust or from the federal government coming to state enforcement. So that's a big mix of great, different perspectives. Having additional education and training has been really important so that we can continue to keep everyone up to date on, what's been happening, where there have been challenges, where there have been successes, what areas what things you need to think about as a state enforcer that you may not have had to think about if you were in private practice. That was definitely something that I experienced when I joined state enforcement from private practice 5 years ago. So that's been a priority, and we've been successful in having a number of trainings that I think have helped with certain issues. One of the priorities also is to just get out and talk about the great work that states are doing. I have had a kind of one goal to, correct any assumptions that people have had that states are just now starting to make waves in antitrust. I think states have been doing great work for a very long time, long before I became a state enforcer. I think that states are getting more attention these days. And I will admit and concede that with the increase in state enforcement resources and adding people, you may see some more enforcement from states because they have additional resources. But I think that doesn't mean that states haven't been doing anything in the past. That's kind of the point of getting out and trying to talk about how all states have been, kind of doing a lot of things that may not get national notice in hospital mergers or other things that are really local. And so that's one of the things that I have a goal of, is to try to get out and talk with people about state enforcement. I think what I'm noticing with states is that they do focus on, I just would say, budgetary issues. My office does as well. And so the priorities in trying to make sure that the committees we have that support things like healthcare, like agriculture and food, like housing, that those areas are represented within the NAAG task force, and that if we need to add or change things to kind of address some of those things, then we will do that.
Now, speaking of the healthcare sector, we had a recent episode of our Curious Amalgam, number 331, for those interested, that focused on state mini HSR laws, state pre-merger notification laws, often applied in the healthcare context. What do you think about those laws? I believe some states are enacting new ones or modifying existing ones to sort of increase their oversight of mergers that either occur within state or will affect a lot of in-state constituents. What's your take on these laws and how they might affect state enforcement going forward?
Yes, so I can speak from some personal perspective because Minnesota passed a healthcare transaction notification law in 2023. And prior to that, we did research into what other states were doing something similar. And then subsequent to that, we continue to follow what other states are doing, what we're doing, and work with those states to better understand how we can do our job in Minnesota well with that enforcement tool. It is an interesting time to be engaging in healthcare transactions because, as I understand, the state legislatures have prioritized healthcare in many of these laws because it is an issue that they want to have the AGs in those states have additional oversight of. And it's for them to be able to know about, see, and learn with enough time to be able to challenge it if they find that it needs to be challenged. I think a lot of state legislators were surprised to learn that state AGs don't necessarily get notification of certain transactions, even if they hit the HSR thresholds because of, it's not intuitive for companies to be talking with states. So they made it required. It also puts states in front of federal enforcers in terms of the timeline for companies working towards concluding a transaction, which is interesting. It's not every state, but many states now have notice requirements that are longer than the HSR 30 days. And so it sometimes means that states are kind of first look at transactions. Separate from healthcare and just broadly speaking, you have the mini HSR laws. Some have existed for a little while and some have become more broad with the ULC model law being passed in Colorado and Washington. And so they will now be receiving significantly larger number of transactions to review and be aware of. I think one other motivation that state legislatures had is looking at the data. How can states better understand what transactions are happening so that, for example, roll-ups or private equity or where is the ownership happening? Not that, private equity is bad. It's just simply harder to know about where the ownership structures are and where they are concentrated. And so I think going back to the healthcare transactions, some of them have blended charities law oversight in them as well. And so I think for those who are looking at it from a purely antitrust perspective, might need to do a little digging into charities in order to ensure that they're meeting the threshold or meeting the requirements under those statutes. And I think the collecting of the data is also a very important aspect that a lot of state legislatures talked about when they passed these laws. And so even if you look and see, oh, I'm fine on antitrust, I'm fine on charities, maybe I don't even need to talk to the state, know that the statutory requirement for the data collection is also really important to state legislatures, and that's what they want. In Minnesota, for example, we have a collaboration with our Department of Health. And so the economists at the Department of Health use the information that's collected to better understand the markets.
That's a very helpful overview. And just to take a step back here, I think it's fair to say that the antitrust bar has noticed that the states are major players in antitrust enforcement. So in this environment, what advice would you have for companies and their counsel on how to engage with the states during investigations? And does that advice differ if it's a joint federal state investigation compared to a standalone state investigation?
I don't think my advice would be different. As I mentioned, in state multi-states, states vote with their feet. When they're in a state and federal partnership, they do the same thing. They make an independent decision. And so most AG's offices have an open door policy and are willing to schedule meetings with anyone who would like to talk. And if you represent a company that's anticipating a transaction that involves a state, or if your client has been in the news for something not so great that involves a state, schedule a meeting to share the information. They will identify someone at a staff level that can meet with you, if not the AG. And we're always going to do our job better if we have more information. And, the point of those meetings is for those entities to simply share the information as their clients see it. And then that way we can do our job better if we have more information to assess. And I think that's just simply the impetus behind the open door policy is we don't want someone to not give us information because they're afraid of what we might do with it. We, often are not trying to go out and look for problems, but knowing what's going on simply just helps us educate our front offices on what may be going on and that they may not have to worry about because we've already reviewed it, as opposed to the fire drill. I would say that's what you want to avoid, is having a state suddenly become aware of something that had been moving along. And maybe you were dealing with a federal partner, or maybe you were dealing with other states. And there may have been some state involvement in terms of how this transaction or this conduct might implicate a state. And you decided not to involve that state. And then suddenly they're aware of it and their AG wants answers. That's when you run into problems of having to do a fire drill with a state. And it could be avoided if you simply schedule a meeting.
Well, that sounds like great advice. Thanks very much, Elizabeth. For listeners who want some more details, we're going to post not only a link to Elizabeth's article on the episode webpage, but also a link to the task force's webpage. And there you will find information about some of the cases in which the task force and its members have been involved. And of course, just reading the headlines, you'll see every day something about the activity of one of the state antitrust enforcers. But now, before we leave, we're going to do our usual end segments with our guest, James.
So we all love antitrust, and we could talk about antitrust for a long time, but we're going to switch gears and go into more something about your personal life. So tell us something interesting or unexpected about yourself that's outside of antitrust and outside of your professional life.
So I've shared this with state enforcers at state enforcement conferences, but not to the broader antitrust public. So I grew up as a competitive figure skater. I taught learn to skate. I coached synchronized skating for more than a decade through college. It was my law school job and as a young professional. And so I really miss working with the kids. You get to see them shine and learn their skill and improve upon it. And I was one of those because I grew up as a figure skater. So getting to see others kind of enjoy the sport is something I miss. Got to participate in this annual skating shows and competitions. So that was something that really, I think, helped me balance law school because it's hard to be stressed out when you see someone, stand up on their skates and toddle for the first time. So it was a great thing for me to balance at the time. I miss it, but unfortunately not able to fit it in anymore.
Wow. I think of figure skaters as hardcore athletes. That's amazing.
Yeah, that's really, really fantastic. And now you do a different type of balancing your NAAG responsibilities with your day job. So now we're going to transition to our final segment, which is a segment that we like to call the Curious Hat.
And now it's time for the Curious Hat.
So Alicia, we now pick a random question out of electronic hat, and Elizabeth has not been previewed the question, and so she's going to have to answer on the spot. And what is the question?
Okay, I'm pulling the random surprise question out of our, we'll call it the crypto hat, and here it is. If you could host any type of podcast, what topic would you focus on?
So I am addicted to book clubs. I am in 3 of them, I think. And so I think if I had to host a podcast, I would probably host one about books and be able to bring authors in and hear from them about how they, came up with the ideas for their books. Also audiobook narrators, because I love a good audiobook. Any
particular genre of book?
The thing about being in 3 book clubs is then you don't stick to any one specific genre but I would say, I think if I have the time, historical fiction is probably one of my favorites genres.
Mine too. Well, thank you, James, and thank you, Elizabeth. This was a very interesting episode. It was great to catch up with NAAG's Multistate Antitrust Task Force. Thanks to listeners. Tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.